Hello everyone, goeiedag, bonjour. On behalf of the Belgian Business Club, thank you for joining us today for a new webinar on very special topic, technology and brand protection when you do business in the US, and especially when you come from abroad and you need to understand the local regulation. Before, a few words about our organization. We help Belgian entrepreneurs to connect with the right professional in the region to stimulate business and enable networking. Our extensive network and knowledge of ecosystems in various industries in the region, including entertainment, give you an interesting entry point if you are looking to open your business or expand it on the West Coast. Last month, we had a very complete webinar on taxation and especially on international taxes. As we are still in the middle of the tax period, I highly recommend you to follow the replay on our YouTube channel anytime after today's program. You can subscribe to our channel so you don't miss any replay, and I will share you the link to subscribe in the chat box right now. Okay, just a moment, it doesn't work. Okay, I will do it later. And today, to talk about intellectual property, I have the pleasure to welcome Nathaniel Lucek, who is joining us from the East Coast. Nathaniel is a partner in the corporate in intellectual property group at Hodgson, Russ, an international law firm based in Buffalo, New York State. They have supported companies expanding into the US for more than 2 centuries. Much of Nathaniel's practice focuses on patent law, including the preparation and the prosecution of patent applications, M&A, and opinion work. Nathaniel also regularly advises clients on intellectual property strategy issues. He has supported patent portfolio development for entities ranging from Fortune 500 corporations to universities and startups. Nathaniel is also Secretary General for the Belgian-American Chamber of Commerce and regularly collaborates with Flanders Investment and Trade. He is usually in Belgium once a year, meeting clients and giving presentations when there is no pandemic. You have today the possibility to ask a question directly to Nathaniel by using the Q&A or the chat box, and we will answer to your question at the end of our conversation. Nathaniel, thank you for joining us. The floor is yours.
Thank you so much. It's a pleasure to be here today, and I appreciate the opportunity to speak. As you mentioned, I'm a partner in the intellectual property group at Hodgson Russ in beautiful Buffalo, which actually it is beautiful today because it is not snowing. Hodgson Russ has over 200 attorneys across 8 offices in the United States and Canada. I'm based in our headquarters in Buffalo. We've been proudly supporting the Belgian-American Chamber of Commerce for a number of years. And we represent everything from Fortune 500 international corporations all the way down to stereotypical inventors in their garage or in their basement. While we're talking about intellectual property today, I have over 200 colleagues that can assist with setting up a subsidiary, tax questions, hiring US employees, contracts, fundraising rounds, or other US legal matters. All right, but enough about Hodgson Russ, enough about me. Let's talk about intellectual property. So we're going to cover two parts of intellectual property today in the US. I'm going to cover patents, and I'm also going to cover trademarks. Let's start with patents. And just to begin, in terms of why you bother filing patent applications, because they are expensive. Patent applications are how you would stop someone from copying you in the US. If you have a European patent, that's great in Europe, or if you have patents in Europe, that's great, but you wouldn't necessarily be able to stop them in the United States if that's where all your patents are based. Investors and partners in the US like to see strong patent portfolios. It's good because if they're going to invest their time and their money, then they want to know that someone else isn't going to copy it immediately, or there's not going to be a competitor that comes out 6 months later to ruin their investment. Patent applications in the United States are more expensive than trade secrets. Trade secrets are free, effectively, but trade secrets are extremely limited. In order to say that someone is copying your trade secret, you need proof that they actually stole it. Whereas with a patent application or a patent, you can then use that against any competitor. And unlike a trade secret, which must remain secret, which is the reason it's called a trade secret, you can show off a patent. So the technology underlying a patent application, you can go share as much as you want after you file. So they are valuable for fundraising. They're valuable as you grow your business in the US. There's two main types of US patents. There's actually a third one called a plant patent, which covers flowers or fruits. We're not going to talk about that today. Utility patents, which is what you usually consider in terms of a patent, that can be a thing. It could be chemicals, it could be new pharmaceuticals, it could be software, a method of manufacturing something, hardware, machines. And I've got two examples over here. One is graphene, and then the other one's a very early 3D printer. The other one is a design patent. Design patent covers ornamental features. It's only pictures. There's very little description. It's only a few sentences. And that is with consumer goods, it's with luxury goods, but it also can be with industrial goods. If you have a particular shape, and I've got an iPhone and an iPod Nano at the bottom, which I actually still use my iPod Nano. All right. So then the question is when? When can you file a US patent application? So remember, patent applications or patent coverage is country by country, and each country or each office that is reviewing a patent application has its own rules. In the United States, it's the first inventor to file. We finally changed that a few years ago to match the rest of the industrialized world. So now it is a race. You need to be the first person to win and get to the patent office and get your patent on file. So underlying any of these answers is usually it's better to file as soon as you can. If you have not filed any patent applications anywhere, you have a year from your first public disclosure. And that could be a demonstration at a trade show. It could be a paper. It could be a press release. It could be an offer for sale. You have 12 months from that date to file your US patent application. Again, it's usually better to do it as soon as you can, but you do have that 12-month window. It's usually better to do that before you do the public disclosure, though. And the reason for that is not every country has that 12-month grace period. So if you go to a trade show, you show off your new product, and then 12 months later file your patent application, it's possible that you've lost the ability to protect your invention in some other countries, like perhaps China or Japan, which does not have the exact same rules about grace period that the US does. If you've already filed in Europe, you have 12 months from the earliest filing date of your European patent application to file in the US. And if you filed a patent cooperation treaty, a PCT application, which is sort of the international application, you have 30 months from the earliest filing date to file in the US. You don't have to remember this. I made a graph or a chart to show this. So the first three on here are what we just discussed, that you have 12 months to file from Europe or 30 months from a PCT. And then there's the one at the bottom, which I want to mention. That's a provisional application. Provisional applications are great for small companies and large companies in the US. These are placeholders. They're not examined. They just sit at the patent office. They give you a filing date for 12 months for whatever is in the patent application. So if you are going to have a meeting on Wednesday and you want to protect your invention before the meeting because maybe it's not under a non-disclosure agreement, or maybe you just want to make sure no one steals your invention, you file the provisional on Tuesday. And everything that's in the provisional application is protected for that 1 year. At the end of the year, though, you need to do a real patent application or a non-provisional patent application. Provisional applications are great because there's no format requirement. It could be a journal article that you're about to publish. It could be a slide deck. It could be a product manual. Rarely does it hurt you to include more detail than that. So the more you can put in is usually better. But it doesn't have to look like a regular patent application. It just needs to describe your invention in some way. If it works out that you have one, you file that provisional application on Tuesday before your meeting, and then a month later you continue to innovate and you have a new addition to it, you can file a second one, and then you can combine them together later, which also is nice. These are inexpensive. They're $150 in terms of government fees for a smaller company with less than 500 employees. And I'm going to say you don't need a patent attorney to do this. Usually I would suggest you speak to a patent attorney before you file, just so you're not forgetting anything, because again, it only helps you with what you put in. So if your slide deck for your pitch on Wednesday doesn't include very many details about the product, your provisional application is not going to be very helpful 12 months in the future. So great tool if used correctly. Chat with a patent attorney and make sure that you're not doing something that could actually hurt you later, because the worst thing you can do is to file something, assume you're protected, go and talk about it with a bunch of people, and then realize at the end of the 12 months that, oh, I didn't actually, oops, forgot about that one little detail. Other things to remember in the US, software here is patentable. It's actually arguably easier to get a patent on software in the United States than it is in Europe. Software in the US, the rejection you usually face is called an abstract idea invention. So just claiming data analysis or calculations, especially if it's just on a generic desktop computer, that's usually not enough. You'll get one of these types of rejections. Then you have to fight it. Either you add in more detail, or you argue that this improves computational efficiency, or that it's linked to a particular type of hardware to operate, a robot arm or something. Show that it's not just abstract calculations, and you can get around that. It can be a difficult argument to make in some instances, but and the other issue with this is that the rules about software continue to change every 6 months. So your patent attorney can help you if you end up with one of these types of rejections. I also wanted to mention design patents. So design patents before, in my other example, were the pictures of the iPhone, the pictures of the iPod. Design patents are growing in popularity in the US. They're very easy to file. They're just drawings. There's maybe 2 sentences, 3. It's a sentence to describe what it is, a sentence to describe what is in all the pictures, and then I claim the drawings that are attached. In summary, that's roughly what it is. You have to rely on the drawings. Good drawings are essential. You'll want to get a draftsman to make them. But you can cover 3-dimensional aspects of it, 2-dimensional aspects of it. Just remember to get everything at the beginning, because it's very hard to change it later. The nice thing about design patents is that it's different from a trademark. You don't need to worry about whether or not a customer was confused. You don't have to worry about whether a customer even recognizes that you're the manufacturer. It doesn't matter at all. If you're holding the design patent and you own it, that's it. That's all you need. You also, as I mentioned before, can protect more industrial products. It doesn't have to be a luxury good. It doesn't have to be a consumer product or something else. Something else that is being imported or manufactured. It can be a fastening system. It could be, a consumable part inside of a larger piece of equipment. You just have to focus on the ornamental pieces of it rather than some of the functional aspects of it. But the fact that it is used for something doesn't matter. The pendency from when you file to when it is picked up by an examiner is a little over a year. You can shorten that to about a month if you pay extra fees. And the overall allowance rate as of this year is 86%. So the timeline would be you file a little over a year later, most likely you'll get a notice of allowance. If you do get a rejection, most of the rejections are drawing related. So they want you to change some shading on one of the drawings, or maybe they want you to change the description of one of the views. It's usually not complex, difficult rejections to overcome, usually. So 15 months after you file, you get a notice of allowance, you pay your grant fee, you now have a design patent with a 15-year life from the date that it issues, and there's no maintenance fees, you're done. You hold on to it for those 15 years. So not only is it easy, not only is it inexpensive, but the added advantage is the damages. If you think back to Samsung and Apple fighting over cell phone patents, one of the reasons that they fought so hard on some of those was the potential damages. So for a utility patent, which again is be a chemical, software, something like that, you need to go back in time. You need to calculate if this person who copied me and ripped me off, if I had negotiated a license with them, what would I have made in terms of that license? How much money would I have received? Or how much money did I lose by the fact that they're selling? With a design, then that involves a lot of expert analysis and guesswork. For design patents, it's much simpler. The judge asks, okay, you were copying their design, their patented design. How much profit did you make on all of the infringing goods? And then the defendant answers, and the judge says, you will write them a check for that amount. Now, it's a little more complicated if you have only a piece of a larger product, but the calculation is much, much simpler. So in terms of differences from what you may be used to over in Europe, so as I mentioned, software inventions may be easier to gain patent protection on in the US compared to in Europe. The other thing to remember is that a US patent covers the entire United States. You avoid any of the nationalization requirements at the European Patent Office. You don't have to worry about filing in individual countries. There's just one patent office for the entire US. There is no patent protection at the state level, so you can't get a New York patent. There's only the federal version. I did want to mention 4 quick issues that reflect other differences if you're coming over. Number 1, the world of patents, the IP landscape in the United States versus in Belgium or in Europe is different. So you may be able to operate without worrying about infringement in Europe. But at the same time, there could be patents that block your company in the United States. So as you're coming over, even if you're comfortable and confident that you have no problems in Europe, you may want to look and see what your competitors or future competitors have here in the United States, not only because the IP landscape could be different, but we're also a little bit more litigious. Our courts are much busier here, so be warned about that. Number 2, you'll want to get non-disclosure agreements or confidentiality agreements. There is no real fallback or standard provision in state law or federal law that says we should know this is confidential, therefore it is. That doesn't exist, at least not in anything that I'd want to rely on unless I absolutely had to. So why is that important? You could lose the ability to file your US patent application. So remember, I mentioned before that there's that 12-month grace period. It's always better to file before the 12-month grace period starts. But if you can't, get that confidentiality agreement so any conversations or offers for sale or other things are covered, and then you at least might have an argument that the clock has not started for that 12-month grace period. Remember, the other thing to remember in the United States is that the standard is the inventor owns it unless there is an agreement otherwise. That comes into play 2 ways. So in the third bullet, if you're doing a collaboration, you'll want to specify who owns any new IP, because you could be in a situation where you have one inventor that's your employee, your partner has an inventor who's an employee. Now you both own it unless there's an agreement that says otherwise. Why does that matter? Well, because if you both own it, you both can do whatever you want with it. So your partner might decide that, well, if I'm making X dollars per year making these widgets with my friend here that I collaborated with, I could triple that if I also sold to all of his competitors and licensed this out. So you want to have ownership set up at the beginning. Other issue is the 4th bullet point, that you want to have IP ownership agreements for all of your employees, all of your contractors in the United States. There is no standard provision that it is automatically transferred to the company. You'll want it written. Most standard agreements include that language. It's important because at the beginning, it might not matter. You can continue, a patent attorney can work even though it hasn't been transferred to the company because it's supposed to be eventually, and that's fine. But then when you're doing a fundraising round, when you're doing some kind of license agreement or something that's important and going to make money, your employee, you have to go back to the employee to say, hey, if you could transfer that over, that'd be great. And the employee might say, yeah, sure, I'd love to for $100,000. So at the beginning, you want to get that in there so that there's no question about who owns what. All right, so that covers patents. Let's jump to trademarks. Trademarks in the United States are similar to what they are in Europe. I mean, it designates a source or origin of goods. In the United States, just about anything can be a trademark. So that could be a word or series of words. It could be a logo like these. It could be a phrase. It could be a letter or group of letters, number or series of numbers. It could even be packaging. This is packaging for software. Or color. It could even be color. This is one of many examples of color trademarks in the United States. But what you want to remember in the United States is we have this spectrum of distinctiveness. So at the bottom is a generic brand name. So that would be like social network for a social networking system or video chat for online meetings. The trademark office will not register that. That's descriptive, or I'm sorry, that's generic. I mean, that takes away a term that otherwise people would need to describe the goods. So you don't get that. At the other end is the fanciful trademarks like Kodak for camera equipment. Kodak is a word that didn't exist in the dictionary. It was just invented. And then there's everything in between. If you're down farther to the descriptive trademarks, those can be difficult sometimes to gain trademark protection on, but it's possible. There are ways either at the beginning or you can put it what's on called the supplemental register where it'll sit for a few years and then you can maybe get registered status later. So if you're choosing a brand, you'll want to think about something that not only is not similar to an existing brand, but the more fanciful or arbitrary it is, the easier it will be to register. The steps to get a trademark application in the US is very similar to that in Europe. You select your name or your mark or your logo. Usually we suggest doing a search just to be sure that nobody is, that no one's doing something similar, but again, that varies on specific situations. You prepare and file it. Usually it's a few months before examination. Hopefully you're immediately allowed. It goes through an opposition period. And then after that, it registers and you get to put a little circle R next to your brand name. After it's registered, have someone watch your trademark at the trademark office. And for potential infringers, that could be your attorney, it could be someone on your team, it could be a third-party service, but you just want someone to make sure that no one's doing something similar. And then you maintain it. So every few years you need to renew it. Don't forget to do that or else you lose your trademark. Circle R is great. In the US, you can use that only when you have a registered trademark. So it's only for goods that are covered by the registration. So even if you have a registered mark for X, you can only put it on the goods that are associated with that particular registration. Be sure to add the circle R, because if you don't, you might be unable to collect all of the damages later. The TM symbol is helpful in the US, but it doesn't have the same importance as the circle R. All right, why would we bother with a trademark? Well, I mean, it's an easy way to fill up your IP table for fundraising. They're relatively inexpensive. They're not hard to obtain most of the time. But there's other reasons. As soon as you file it, it's published at the US Patent and Trademark Office, which could discourage another company from doing something similar. So they might do their own search and see that you have a similar mark and think, I'll change my name. So you've saved yourself hassle later. US examiners refuse marks that are similar to yours. So they're actually doing your job, your work for you for free. They will prevent someone else from getting a registration on something similar to your mark. Eventually your mark becomes incontestable, which is helpful. It means that if you want to fight it, you can't fight it that it's a descriptive mark. It's been out being used continuously for too long. You get national protection as of the date of your application. You don't have to worry about individual state-by-state coverage. It's a federal mark for all 50 states. You can use Circle R, which provides some notice that you're protecting your brand. You're going to take it seriously. Don't copy me. If someone does copy you, you can use federal court. And in federal court, you have statutory damages, which makes it easier to compute what someone would owe you if there was a copycat. And then one of the more interesting aspects is if you do have a federal registration, you can stop imports into the United States. So you register your mark with Department of Homeland Security, and they will intercept infringing goods at the border. Saves you time and money. In terms of differences, the biggest difference in trademark law between Europe and the US is that the US requires actual use. So in order to register your trademark in the US, you need to be using it with consumers. It needs to be used in commerce. Same for when you renew it. If you're not using it anymore, you don't get to keep it. There is a way to file in the United States. It's called an intent to use application. So that what you're saying is, this is going to be my brand. I promise I will use it someday in the future, but I'm not using it with customers yet. So that can give you, it can lock in an earlier date, put people on notice that you're going to use it, but it doesn't have, you won't be able to register it until it's actually used with customers. The other difference is that the United States usually requires more detail about the goods and services compared to Europe. So in Europe, you might just be able to say software. In the US, you're going to have to say software for what, which narrows the scope a little bit, but it also narrows the universe of what the examiner needs to search. So maybe it helps you. The other big difference is in terms of oppositions. Oppositions are when the mark is allowed, but it hasn't registered yet. In Europe, that's really a paper process. In the US, it's almost like a small trial. So it's significantly more expensive here than over in Europe, if you find yourself in that situation, or if you want to oppose someone else. All right, so that is that's what I had in terms of presentation. I am happy to answer questions, and of course, you're always welcome to reach out to me after if there's something that I don't cover today.
Cool, thank you so much.
Yeah.
Wow, a lot of information you shared today. It's wow, that's great for our guests today. We received some questions for you, two in the Q&A chat. How to apply for international patents while filing the US non-provisional patents?
Sure. You have a few different options for that. You can either file well, you have three main options. Either if you're you can file a US patent application first, and then 12 months later, file that PCT application, or go into countries individually. So maybe you wanted to file in France, China, and Japan. You just file those specifically and skip the PCT application. So that's one, file in the US, then file international in 12 months. Your other option is file somewhere else and just do the reverse. So you file somewhere else first, then file internationally, which eventually will make its way to the US. Your third option is you just file that PCT application immediately to then eventually make its way to the United States. PCT application is a vehicle, I guess is the best way to describe it, to get your invention to multiple countries at once. So the PCT application is based at the World IP Organization in Switzerland. It's examined, but the search results aren't binding. Really what it does is you file under this treaty, it sits at the World IP Organization, it publishes, and then when you hit certain dates, you then send a copy of that to whatever countries you want. So just about any industrialized country is on the list of places that you can file in. The major exception usually is Taiwan, which is not party to the treaty. And then the people, the attorneys in each of those countries will take the PCT application, they'll translate it into the local languages, they'll reformat it, and then it's as if you filed a Chinese application or a US application much earlier, and you don't have to file individually into multiple countries at once. It also postpones some of your costs anywhere from 12 to 18 months, which can also be quite handy because patents can be expensive.
That's true. I have another question. When I have a US patent pending, is it legal to sell it to my own company so the company will own it? Or I can sell only official patents? Shall I involve IP attorney to make the exchange of IP?
You can transfer patent applications or patents. So even though it's patent pending instead of patented, you can still transfer it. There's no requirement to involve a patent attorney in the transfer. You can usually find good templates to do that. Of course, I always suggest getting a patent attorney involved to prevent any problems. But you can transfer it to the company at whenever it makes sense to do so. Just be careful that you use a template that offers you something in return, or else it's might not be a valid transfer. After it's transferred, you may want to record that at the US Patent Office, which again, that doesn't cost anything. That just puts people on notice that it is now owned by someone else. Recording the transfer is not required, but it is an option. It's usually a good idea. It does make things simpler if you're ever seeking, doing a fundraising round, because then it's already recorded at a government agency. You don't have to provide all the documentation to show that everything was transferred to the new owner.
Okay. Another question came into the chat box. What are the implications of the US common law versus European civil law system with regards to technology protection? Doesn't it favor richer company with more money to spend on lawyers?
To some extent it does. But the US Patent Office is trying to help individual entrepreneurs and smaller companies. There is a cost discount on the government fees to in terms of what the patent office fees are to file for examination and other things that can help save costs. If you're looking for attorneys, if you look outside of major metro areas, that also might reduce your costs if you're a smaller company. On the enforcement side, that's true. Litigation in the United States is common and expensive. There are ways to try to reduce your costs. I mean, there are organizations that help fund patent litigation in return for a percentage of any profits or judgments in the future. You also could try to find law firms that are willing to work out a deal depending on your case, but it is an issue that it's tough if you're just a solo entrepreneur in your basement and you're fighting Google. That it might not be an easy battle to win, but people have done it. It's just a matter of sticking with it and trying to find the right combination of attorneys and being in the right situation at the right time.
Okay. Another one, can it hurt to file for IP patent if it turns out it's already protected in the US? Or is it a good way to check if my IP is unique and is filing the more the better, a good approach?
So you can file in the United States and see if anyone else has something similar. That's an expensive way of doing it. You can get a good search for a few $100s from a third-party vendor, which will give you a series of results to see what is out there. I mean, obviously that won't ever get you a granted patent, but if all you're doing is looking for information about what the IP landscape is, you can talk to a third-party search firm for that. It doesn't. The only way that one of the ways it could hurt you would be, though, if you do file, your patent application is rejected using another company's existing patent. Some companies watch to see when their patents are used in rejections. So it might alert the other company to your existence and that you're doing something similar, which might cause them to investigate you and your technology a little bit. And if, I mean, it's not automatic that if a patent application is rejected using someone else's patent that you infringe that patent, but it is a possibility. So you want to be careful if you're just testing the US market with a patent application. There's cheaper ways with less exposure to get to a similar result.
Okay. And I have a last question from, I think, an entrepreneur in the food industry. I'm in the process of picking a new name for my new business operating in the food industry. What should I keep in mind to pick a good and protectable name?
Sure. You'll want to, this goes back to that degree of distinctiveness that I mentioned earlier. So you'll want to choose something that is not descriptive. And that's number one. So try to find something that is creative, maybe invent a word or do a play on words, which might be helpful. So all of that would be good. The other thing to look for is have a search done if you have time and the resources to do so. If you have a search done, that'll prevent you from finding that there's something very similar, which could prevent you from getting trademark protection at the end.
Okay. So I think we are nearing the end of this session today. Thank you so much, Nathaniel, for your time today and your valuable advices. This conversation will be available in replay on our YouTube channel soon. I just put the links in the chat box, as well as the LinkedIn profile of Nathaniel if you want to contact him. And so it is. Thank you and have a nice day all. Thank you, Nathaniel.
Thank you.
Bye-bye.